Well, good morning. Oh, good afternoon now. Thank you very much, everyone, for joining us. And thank you very much, David, for joining us too. For you who don't know him, this is David Sorensen. He's managing partner at Morrish Solicitors, who has kindly agreed to give us a legal update. I think it's a good time, actually. It's an interesting time in regards to a few things which we'll be touching on, well, which David will be touching on today, not namely artificial intelligence and how that's going to be impacting employment as well as, I guess, the law, with the government adopting a pro-innovation approach, which basically means light on regulations, which I think is an interesting, if not terrifying, prospect. And the evolution of Britain following our departure from the EU, which continues to rumble on. So David's here to just basically put us make sense of it all and put all of our minds at rest there. So without further ado, I'll pass you over to David.
Good afternoon, everybody. And thank you very much, Nick, and thanks for letting me join you. Can everybody hear me okay?
I assume so. They're all muted, David. So.
Oh, of course, yeah. Okay, well, I'm from the Morrish. I'm from the Morrish whitewashed police interview room. It looks like, and every time I do one of these, I keep thinking I ought to get some pictures in the background. So I'll have to work on that for next time. But today I'm joining you with a mixed bag of employment stuff. So Nick, if you don't mind lifting up the slides, and then we can have a look at those, and I'll take you through it. Thank you very much. So yeah, as Nick kindly said, I'm going to be touching on some very easy topics: artificial intelligence, Brexit, and various other things. And if Nick, you don't mind just moving through to the next slide, we'll have a quick look at the slides as we go through. Oh yes, there's a little bit about us, but I think hopefully you know all about that. Morrish is 141 years old this year, and we've obviously been doing employment work and acting very happily with trade unions and associations for quite some years now. But that's enough about us. Let's get on to the agenda if we can. So if you don't mind moving on again, Nick, there we go. So what I'm going to look at is some legislative changes. So these are areas of law that the government are looking at implementing. A couple of cases on a case law update, touching on social media, another easy topic, and then dealing with artificial intelligence. So for Nick, if you don't mind moving it on. So some recent changes, just a couple of recent things. Firstly, next time you're in an employment tribunal hearing or an employment appeal tribunal hearing, you can now refer to judges as judge. So gone are the days of sir or ma'am or madam, but it's judge. So it could be good morning, judge. Good afternoon, judge. All sounds a bit weird to me, but there we go. That's the terminology they want us to adopt. And then secondly, a recent change, and a welcome one, given the rising inflation, is that the caps on unfair dismissal and other compensation have gone up, and they've gone up by over 12, nearly 13%. So unfair dismissal, basic awards, statutory redundancy pay, the cap there is lifted. Compensatory award now is over £100,000 potentially. It's not quite often that generous, as we all know, but the compensatory award cap has gone up to quite a significant amount. And also injury to feelings for any discrimination claims when an award is made, those have been uprated too. So those awards are more chunky, but of course that just reflects the rise in inflation. And if you don't mind moving forward, we're going to start looking at some changes that the current UK government are discussing. And for those who have been keeping an eye on these things, the changes to the tipping requirements, particularly in hospitality and so on, hotels, have been under review by the government for the best part of 6 years. And finally, the Employment Allocation of Tips Act has received royal assent. We've not yet seen the meat of what's involved, and there are some guidance and there's some regulations they're going to be published. And what it's going to require, we know, is for every employer to have a written policy on the fair distribution of tips. And for those of you like me who have in the past worked in the hospitality sector, we all know there's all kinds of variances in the way tipping is given, and also quite disturbing for many of us. We all know that often the chain, say a large chain, can withhold tips or use tips towards national minimum wage and things like that. So hopefully, when we have the detail, this will be a positive development. So tips, keep an eye out for anyway. And then if we can just move on. We've also just recently, in the last couple of weeks, and this is partly linked to the Brexit sunset clause, which I'll talk about in a second, but the government have rolled out what they call smarter regulation to grow the economy. All sounds a bit like Liz Truss in terms of the push to grow the economy, but they're the buzzwords that Mr. Sunak's using as well. So they've rolled out some announcements of consultations they're wanting to do to have smarter regulation to help grow the economy as they define it. And one of the kind of odd areas to start, really, in my opinion, is to start tinkering with non-competition clauses in contracts of employment. So the government are consulting about bringing on a cap of 3 months post-termination, how long somebody can be restricted from being able to compete with their ex-employer. Often you'll probably have experienced 6 months notice periods, 12 months notice periods, maybe some companies even trying for longer. Generally speaking, 12 months seems to be about the norm, but the government have decided to tackle this, and they're consulting about the idea of having a 3-month limit. And the idea behind it is to say that having a longer limit is restricting growth of the economy. So reducing the limit means people can start competing with their old employer sooner. And it's also designed to apply, if it goes ahead, to workers and employees, so not just employees, but they've identified it's unlikely to apply to contracts and agreements of partnerships, LLPs, self-employed consultants, business sales and shareholder agreements. Also, it's not intended to apply to other restrictions post-termination, like non-solicitation, non-poaching. So those sort of limits on people taking their colleagues with them when they go to a new employer will probably still stay in place, but the limit will apply to non-competition if it comes in. So it's a bit of a curious area to start on, but that's one thing that flagged up as part of this proposal. And Nick, if you don't mind moving on to the next slide, we can then get to what was being called the bonfire. And we've kept hearing this phrase, bonfire of EU law. And there's been a bit of an about turn, and many of you no doubt have kept an eye on this, because what has been thundering down the track is the sunset clause to apply from New Year's Eve this year, a bonfire of EU regulation. And I think if you've been following this, you'll have seen virtually every business organisation, virtually every union, many organisations saying this is a bad idea, because there will be, and this was the other point, nobody quite knew how big the bonfire would be, because it seemed nobody had counted up the EU law that was concerned. At one stage, they were talked to be about 2,500 pieces. Then they actually looked at maybe 5,000 pieces. And from what I was hearing, the civil servants assigned to review this and what would stay, you could count the number of them on 2 hands in terms of who were actually assigned to look at this. So the idea of crashing out of all this law by New Year's Eve this year seemed like a disaster in the making. And anybody sensible, you think, even somebody who would be an arch Brexiteer would say, well, hold on, it can't all be bad. Let's look at it. Let's carefully review it before we throw things out. And it seems that Mr. Sunak saw some sense with that and has decided basically to retain the body of EU law, save for regulations and pieces of law that they identify as needing to go or to be changed. And they've already flagged up 600 of those, half of which are environmental protections, which I am not an environmental lawyer, but I would be concerned if I was, well, just as a citizen, that 300 pieces of environmental protection are going. But there we go. Employment law wise, thankfully, the number to go is being reduced, and the government have flagged up a consultation about the bits they think should go. Chiefly, parts of the working time regulations, which we'll talk about in a sec, and some TUPE protections as well. And so what they're consulting about, and the consultations until the 7th of July this year, in terms of the working time regs, is to merge the current basic and additional annual leave entitlements into a single 5.6 weeks, because those of you who know EU law and working time regs will know that there's a 4-week Euro leave element to it, and then there's a 1.6 weeks additional leave. The government are talking about merging the two together, which on the face of it, you think, well, that could be quite sensible. But currently, the Euro leave attracts things like overtime and commission and things like that into the calculation of holiday leave, whereas the additional element doesn't. So the question will be is if they merge it, how will you calculate the annual leave pay that someone is entitled to for taking annual leave? Will it be back to just basic pay only, and possibly losing voluntary overtime and other payments that are currently should be included? It's quite a complicated area, but the fear is, from our point of view, is it could reduce the overall amount. So individuals taking annual leave may actually only be receiving basic pay, sorry, which for some people who are commission based or on overtime and other elements could reduce it down and also deter people from taking all their annual leave entitlement. The other thing they're talking about, two other elements which we need to keep an eye on, is introducing rolled up holiday pay, so that everybody could receive rolled up holiday pay as part of their normal pay, rather than it being calculated when that person takes annual leave. And you may think, well, why does that matter? Well, for those individuals who work in a very busy period up to when they take annual leave, when they take leave, currently their holiday pay can be calculated based on a very busy period. It's less generous than it used to be because of changes the government already made. Whereas if it's rolled up, chances are it's going to be a lower amount. And again, it might deter people taking annual leave. There's been a lot of abuse of rolled up holiday pay in the past, particularly those who are on sort of peripatetic and casual and 0 hours contracts. And then the third thing is a typical Conservative approach, which is to reduce record keeping. So currently, annual leave entitlements, other working time information needs to be retained by the employer, and the government are consulting about scrapping that requirement, which is odd given that some of that has to be retained for national minimum wage purposes anyway. But my personal view is that the Conservative Party as a whole has always hated the working time regulations, and TUPE, to be fair. And so this is sort of really comfort to the Rees-Moggs and others in some way to try and show that the red tape of European law is being cut. But I've just got a quote from him who had a massive reaction to this, because of course he and other arch Brexiteers have referred to this as a massive climb down. And Jacob Rees-Mogg, in his own certain style, said this is probably more down to civil service idleness, as in the civil service can't be bothered to review the employment law and the other laws before the New Year's Eve, or a lack of ministerial drive. So he's clearly unhappy about it. To me, that's a good thing. If Rees-Mogg is unhappy about something, then I think that's a real positive, and I'm delighted, just for a principle. But anyway, maybe I'm getting too politically involved on that one. So Nick, if you don't mind moving on to the TUPE. And for those of you who recognise the hand, that's Mrs. Margaret Thatcher behind the hand, because she has never been a friend of the TUPE protections. So I've sort of jokingly added her here. You may recall, those were long memories, that she was forced to implement the TUPE regulations back in the late 70s, trying to oppose it, and the EEC, as it was, brought infraction proceedings against the UK to require her to bring it in. So there's always been a candle there burning amongst certain elements of the Conservative Party about cutting TUPE. And lo and behold, here we go. So there are two potential changes that may come in by the end of this year, which is allowing small businesses with less than 50 employees to consult directly with their employees if there is no existing employee representatives in place. So if there's no recognised trade union, there's no existing sort of elected company council, then they would not have to go through that process of electing employee reps to consult with if there's less than 50 employees employed. And similarly, if the TUPE transfer probably involves less than 10 people, then there is no need for any company, any employer, to consult with the existing employee representatives. That's a concern, because sometimes TUPE transfers can involve just a handful of people, or even just one person. But that would potentially take the union out of the equation if there's less than 10. And of course, it could be that if this goes through, that what an employer might do is have 10 now, then transfer another 10 for a few months down the line and so on, and space it out to try and avoid this as some kind of chippy avoidance. So we'll need to keep an eye on these things, but these are two potential things that the government are consulting about until early July, with a view to that New Year's Eve deadline. And Nick, if you don't mind moving forward a little bit. Slightly more positively, you may also have been watching private members' bills that have been going through Parliament in London, and where private members have put these forward and the government has now decided to support them. This seems to be a current fashion where I think where a government is not particularly keen on employment law or increasing it, private members are allowed to bring these things through. So I'm just going to break down these three discrete acts and what they can provide. Nick, if you don't mind moving us forward one. So let's have a quick swig of tea. The Neonatal Care Leave and Pay Act. This is a positive. It's designed to give up to 12 weeks neonatal care leave per parent, in addition to other statutory leave entitlements. This is potentially a day one right, and the actual pay for it, you'll need to have at least 26 weeks continuous service and certain earnings, but it could be that's quite a good benefit. Now, the slight downside is they've identified that it won't be in before April 2024, and it doesn't take a rocket scientist to work out that we may have a different government by then. So it may be a little bit of an empty promise by the current government, but we'd hope that if the government changes next time round, that will be honoured. But that's one thing to look out for, but not yet. And then if we can just move to the next one. This is another thing that's been discussed since, I think, Boris Johnson's time when he was Prime Minister, which is to extend the protection against redundancy for those returning from maternity, adoption and shared parental leave. Because one big hole in the protection is that when that person comes back, then they can lose that protection against special treatment against redundancy. So again, the fear is that a particularly unpleasant employer may then target them after they've returned. So this is designed, and it's hoped that it will give 6 months additional protection from the return. And if that does come in, that can only be a good thing. And then, Nick, if you don't mind moving forward to the Carers Leave Act. And again, a potentially positive right, a day one right, which allows, this is the downside, 1 week's unpaid leave. So an employer can take 1 week's unpaid leave to care for a spouse, a partner, a civil partner, child parent, a person who lives in the same household, or a person who reasonably relies on them for care to take time off the care. Now, there's going to be certain conditions to meeting that, but that's a potentially very helpful right as well. Sadly unpaid, so it may have limited take up, but it's designed there to allow time off for caring, and not just for children, but obviously other people in the household and so on that meet those requirements. And if we can move on one more, yeah, just to go on, it identifies those requirements, identifies that the individual can self-certify their eligibility for it. But again, it's one we might have to wait for a little bit, because they indicate it won't be coming in until April 2024 at the earliest. So there's the three private members' bills, but there are some other proposals on the table. So some other areas the current government are looking at. One of them is the consultation about making the right to request flexible working a day one right, and also that the all-party parliamentary group on modernising employment formed to make UK. Sorry, going back to that right, that was also talk of strengthening the rights, so to make it a stronger right in terms of the entitlement to it. And then what we're going to talk about shortly as well in terms of other government proposals, the set up a new all-party parliamentary group on modernising employment, which is designed to speed up hiring, improve inclusivity, using technology better, and using collective regulation, which we'll touch on when we talk about artificial intelligence as well. So that group has been formed, I think, last week or the week before. So in terms of looking at those sort of areas where there may be efficiencies, as they call it, or reforms to the way in which the process is currently operates and the system operates. So, and then if we just move on. I'm afraid any legislative update has to touch upon strike laws, because certainly in our experience and our knowledge, strike action, industrial action isn't going to go away and is predicted to rumble on. And there are various unions that haven't yet been taking industrial action, but are now looking at it and balloting members as well. So it's definitely a very warm area. And of course, as part of that is the minimum service levels bill, which the government are keen to pursue. And just a quick update there, really. I'm sure you're aware of the situation, but very recently, House of Lords amendments that wanted to limit the extent of the bill to England, because it's particularly unpopular in Wales and Scotland with the devolved powers, devolved governments. It was also, the House of Lords wanted the government to be required to consult with the House of Commons and the House of Lords on how minimum service levels operates, because quite scandalously, the government have not set out the detail really of how this operates. That detail is currently not available. So the House of Lords have picked up on that fear and said it should come back to us so we can go through it when you provided the detail. But the House of Commons has rejected that. Also, to improve the information that needs to be given to individuals who receive work notices, so that their protections are there and stronger, and for fear of dismissals taking place fairly, because of the quite confusing nature of how work notices and minimum service levels is probably going to work. And also there's quite a unclear requirement on unions in terms of taking reasonable steps to work with employees and work with employers regarding work notices, and how to actually make that sort of work practically is going to be quite difficult. But the House of Commons have rejected that too. But hopefully during the debate, Angela Rayner MP has confirmed in Parliament the Labour Party opposes the bill in its entirety. So if it does come in, they've now committed to repealing it if they win the next election. So that is the minimum service level update. And that covers legislative changes, of which there are a few. There's some positive things in there as well. A number of those have been promised for years and years, and hopefully will come forward. They're certainly not being rushed through, but hopefully those things will come in, and some of those are positive. Obviously, minimum service levels isn't from our point of view. But also what I then do before we get into artificial intelligence is look at social media and a recent case, because we've got two cases really to update you on. One of them is social media and the law of unfair dismissal and how that interacts. And the other is just an interesting case, similarly, about behaviour in the workplace and how that links into discrimination and disabilities. Now, the case of Webb is actually an employment tribunal case. Normally, when we give updates, we look at appeal cases because they're binding. But the reason I've chosen Webb is because it's very illuminating of the tension between social media and employees' use of social media and the risk of getting dismissed and how that works. So it's a sort of a textbook case, really. So I'll give a little bit of background. I'll also quickly just mention Mr. Gary Lineker, of course, and the situation with the BBC just a few weeks ago. Seems like ancient history now, but it was just a few weeks ago. And I think the take home from that is, now he's in a self-employed position, so it's not strictly employment law. But the take home from that was, it was clear that the BBC didn't have a sufficiently detailed and restrictive social media policy to pin him in. So his argument was, well, you cannot restrict me from saying I want to say when he was commenting on migration and the issues there and how the government has behaved. So he had a fairly good legal basis to say, hang on, you can't restrict me in this. And I think while that doesn't directly play into employment land, as it were, it's still relevant, because when we get in situations where we're advising members on how to handle social media and the consequences of mishandling it, the social media policy, the written policy, the policy on social media itself, the disciplinary code, that is key to look at that. Now, one caveat to that is some things on social media are going to be so obviously gross misconduct that not having a social media policy that defines that as being inappropriate isn't going to be fatal to the employer being able to fairly dismiss, because some things in reality, there's some dreadful things on social media are so obviously wrong that you can think, yeah, that's gross misconduct, no doubt about it. But often those aren't, and it's a question of interpretation. So I think the Webb case is quite informative. I'm going to quote a little bit from it. It's quite a sort of disturbing case, really, because it harks back to the situation back in 2020, because it was all about postings on Facebook by a London Underground train manager regarding the murder of George Floyd. Obviously, the terrible situation that happened there that encouraged the great growth of the Black Lives Matter movement in terms of mistreatment, that started with obviously US police murdering him, and it was all about social media comments that this manager made. And I should explain, the manager itself had been employed for 32 years and had previously had a clean disciplinary record. She was a white woman, but started commenting on this on the day and around the time of the murder. Now, I'll briefly go into the comments because I think it helps to sort of inform it, because when we look at social media use in the employment context, it's always a question of analysing what's said and the factual situation. But effectively, she really made a series of posts, one of which was a photograph of George Floyd, in which she commented, the media and the left made George Floyd into a martyr, but who is he really? And there then followed a list of alleged criminal convictions he had, including armed robbery and drug offences. And at the bottom of that, this was not her post. She was reposting it to friends, but she commented herself, never deserved to be murdered by a policeman, but really was not a nice guy, about George Floyd. Now, I should say that she worked in a very diverse train depot, managed hundreds of staff, who were very diverse, and this immediately caused some uproar. He then went on to post some more and started referring to the death of Lee Rigby several years before, and identified on her post in May 2013, no one rioted in the UK when two black men hacked Lee Rigby to death. It's time to bring back the death penalty. Where we all then? All lives matter. And these comments were superimposed over the top of photographs of Lee Rigby and his black assailants, one of which was taken in the immediate aftermath, and blood his hands. And then she reposted that and then got in further comments in terms of the Black Lives Matter protests, adding a comment to a photograph of a police officer with a bloodied head about the protests that were happening in London, commenting, agree, time to hit back hard like in other European countries, tear gas, bullets and water cannons. Would these arseholes behave like this in Russia, Italy, Greece? No, they would not. So these comments were being posted on, and she then got an interchange on Facebook, saying, with a colleague who criticised her, saying, not afraid to call scum scum, not due to colour, race, sex or creed, so wrong he died, but I for one am not sorry, he's no longer here to hold a gun to another pregnant lady's stomach whilst robbing her in his own house. Now, what also transpired is that a lot of the accusations she was making against him, and of course he'd only just been murdered, weren't accurate. So this whole situation became extremely serious in the workplace. So you can imagine the uproar that was caused, and London Underground, obviously being a public sector employer, the uproar reached the sort of mayor's office and the commissioner of transport and so on in London, so it became very serious. And of course she was then suspended. I think when we look at the context of that, you can see that she ran arguments about human rights and privacy, about free speech. She also identified that the postings were private postings amongst her many friends on the social media platform. But what was also clear was many of her friends were actually her subordinates in the workplace, and it was clear that it caused massive upset to those as well. So anyway, the long and short of it, she was dismissed for gross misconduct, and this is a textbook case really in terms of this situation, because what became clear was London Underground had a very clear social media and disciplinary policy. She was also aware of it and had been trained on it, and that was documented. Many of her friends on her social media platform were her work colleagues. She also identified that she was employed by London Underground on the platform as well. And to compound things, when she was requested to initially remove the post, she refused to do so by the employer, but she eventually did. So those posts went viral, of course, and it spread much more widely. And I think it's worth just looking at the way the tribunal approached it, because she obviously appealed internally, she was unsuccessful, and the dismissal was upheld. And then it came to the tribunal. Now, the tribunal judgment, just to show the level of detail, is over 30 pages long. So lots was considered. But I think the key thing the tribunal found was that her behaviour was inflammatory, offensive, racially divisive, social media posts contrary to the code of conduct and social media policy. And there was a clear and present need for London Underground to act in light of the posts, and that need was pressing and obvious. They then looked at the way in which the company had gone about it, and looked firstly, as we always must in an unfair dismissal claim, is there a fair reason? And found there was conduct in itself. And they identified that given her position as a manager of an ethnically mixed team, it was particularly serious. They identified it may not have been her intention to have her employer involved in her debate, but the evidence was clear that in the public arena, her views were being associated with London Underground in a way which was wholly unacceptable. And it was possible for her to work out from the policies, if she chose to do so, what she was permitted and not permitted to do. So there's no doubt about her obligations that she'd agreed to. And then, of course, the second question the tribunal adopts in an unfair dismissal case is whether a fair investigation has been completed, whether the employer has acted reasonably, and whether the decision to dismiss is in the band of reasonable responses which a reasonable employer might have adopted. And the tribunal found it was our view that, having regard to the nature of the posts and the overall context in which they were made, that the decision to dismiss fell within a band of reasonable responses. Firstly, we'll bear in mind that the social media messages were offensive, inflammatory, and racially divisive. Secondly, and this is another factor, the claimant showed little, if any, insight or remorse. Thirdly, she was a manager in a culturally diverse workplace with line manager responsibilities for an ethnically mixed team. So it really is a textbook example of where the employer has got it significantly wrong, where postings weren't taken down initially, no remorse was shown, no appreciation really of the significance of the postings. And so I think it's just, if you get a chance to have a look at it, please do have a read. It's obviously, it's of interest more widely. It was a big issue, obviously, back in 2020, and the Black Lives Matter movement is of obviously significant importance. So it's a case of real relevance. But I think a very good example of any social media kind of dismissal, and how an employer, while they didn't get it all completely right, ultimately they got the majority right. They had the policies in place, and it was a fair dismissal. So that's that one. And then the other case is also about workplace behaviour. So bodily, I've got into two cases really involving conduct in the workplace, but this is another one that's quite topical. And this is where we have an employee who is a disabled person, and he has Asperger's and a neurodiversity condition and partial deafness. And what was becoming clear in terms of his conduct in the workplace was he was reacting to management instructions and management requests in quite an aggressive and intimidating manner. They were defined as meltdowns, and ultimately that led to disciplinary action and ultimately to dismissal, because one of his female managers in particular was offended by his kind of backlash to her. And he stated, and this is something that isn't uncommon, but he stated that my behaviour and that my aggressive but intimidating behaviour is linked to my disability, and a consequence of that. And therefore, to discipline me and dismiss me is discrimination arising from disability, and is protected. Now, you'll know that that type of claim can be defeated by the employer if the employer can show that the action they've taken is a proportionate means of achieving legitimate aim. And that's, of course, what the employer argued here, that we cannot allow intimidating behaviour in the workplace, and despite any disabilities, we can justify a disciplinary code and taking disciplinary action because of that. And that's a proportionate means of achieving a legitimate aim. And the tribunal ultimately found that that would have applied here, that behaviour, there's not an excuse for aggressive and intimidating behaviour. But interestingly, so that would have applied here, and that's irrelevant really when we're acting for members, and members' behaviours may be inappropriate, but may have certainly at first sight a link to their disability or their health condition as to why they're behaving that certain way. Now here, unfortunately for the claimant, the tribunal reviewed the medical evidence and actually found that the meltdowns and the behaviour wasn't a consequence of his disability. I think they had the ultimate put down really. They found the reason he behaved like that was because he had a short temper. He didn't like being told what to do, and it wasn't caused by his disability, which is a bit of a basically he got very cross, but it wasn't linked to his disability. But I think it's just a worthy case to bear in mind, because we do get those situations. I mean, we get both in terms of social media, hopefully not an extreme case like the one we've talked about in web, but social media use and where the limits lie, but also in terms of behaviour in the workplace where they may have their core, the health condition. And so what the latter needs really is a detailed assessment of what is the cause for the behaviour, because here the medical evidence didn't support the claimant's suggestion that the cause was his disability. The cause was, the medical evidence suggested, just because he was bad-tempered, really, and it wasn't linked to his disability. But the tribunal, the Employment Appeal Tribunal, I should say, went on and found that even if it was linked to his disability, there's a limit to how far that can go. And that's worth bearing in mind as well. So there's a limit. It doesn't give you an individual carte blanche to behave inappropriately. They've still got to temper their behaviour to fit within the wider workplace. So two cases I hope of interest. And then we're then going to touch on the topical topic of artificial intelligence. And I seem to be walking a well-trodden path over the last couple of weeks where there's been an awful lot about AI and the impact of it. And I don't suggest to have all the answers here. I can make some points that are hopefully topical, but it's very much an area that's being walked at the moment, and there's quite some way to go with it. I'm going to look at it from an employment perspective. There's loads of perspectives to it, but interestingly, of course, some countries have already banned ChatGPT, France, China, and then some of these slightly less democratic countries, I think we can be fair to say. So I don't know how other countries are going to deal with it. I think there's talk of Italy as well. There's restrictions being brought in, but also some companies have banned it internally. Samsung, but that's maybe partly because they're developing their own AI and they want to keep it to themselves. But there are obviously limits and there are fears about how far it will go. Currently, there is no overarching law or regulation of AI, and as Nick has so helpfully suggested, the government seem to be talking about a very light touch approach, which is always slightly terrifying when you hear the words light touch, because you tend to think that means sort of no touch really. Very limited restrictions on it. But we do have the current protections that are in place. And I think I mentioned the four here. There's the Human Rights Act. Now, not too long ago, the government's looking at altering that, but those seem to be put on ice. I can see, actually, there's a slight typo there, because it says the Human Rights Act 1888, and it's actually 1998. So apologies for that. That's not very good. The Employment Rights Act 1996, so that's the unfair dismissal and so on protections. The Equality Act 2010, and that's particularly on message, really, in terms of discrimination protections, and good old GDPR. And as you'll know as well, there are various potential changes to GDPR, but currently the protection is pretty strong in terms of that and limiting it. So the government, what they've done? Well, they said they're going to issue a roadmap. That's another word I don't really like the government using. The light touch and roadmap. Roadmap always sounds a bit, to me, a bit optional, because you don't always have to follow the roadmap. You can try and piece it together yourself. So we'll see. But they're promising to publish that later in 2023. And they've set an internal deadline for spring 2024 for a UK regulation roadmap. So we'll see what that produces. But I imagine that'll probably be quite voluntary in terms of the things it needs to meet, because that's often the way the current government have gone. And Nick, if you don't mind moving on to the next slide, I just want to look at some detail here, because very recently a Labour MP has put forward a private members bill to kind of bring in some restrictions and regulation. And now how far that will get remains to be seen. Whether the government will support it, again, remains to be seen. I'm not particularly hopeful, but it gives some kind of ideas of how it could work. So where they identify that high-risk AI should be particularly focused for further regulation and require sector-specific guidance on what it means and how it would operate, and use recommendations from the TUC. A statutory duty for employers to consult with employees and trade unions before introducing AI into the workplace. I mean, that would be great, but obviously many workplaces have already brought it in to an extent. AI really isn't anything new, but of course the chat bot and other elements of AI software are new to market, as it were. There's potential establishing a universal comprehensive right to human review high-risk decisions made by AI, so to keep in human contact to monitor it. And also linked to this, but slightly separate, is a right for workers to disconnect. Because one thing is clear, is as we know in the workplace, that there is a lot of linking in to digital systems, tracking, either be keyboard use or activity online, or working, say, in a warehouse environment, how quickly people are moving, how long they spend in the toilet, all those kind of things. But also there's a blurring of work and home life, and so there's a proposal here that's been talked quite regularly about a right to disconnect, which obviously I think from our point of view we see is a very good thing, to kind of bring in barriers between that because of the very nature of tracking and all those other elements, not least in terms of things like mental health, constantly feeling monitored, and that is an issue. I saw some statistics yesterday where I think now 70% of workers are genuinely monitored in terms of keyboard and other use, software use in the workplace, which is pretty shocking if that's an accurate statistic. But so that's a blueprint, potentially, of certainly a starting point of where AI regulation could go. I should also say the EU have got AI regulation under review, and I would anticipate that they will probably bring in the highest level of protection. Not because I think the EU get everything right, I don't by any means, but they tend to lead the way on these things like they have with GDPR. So that will be interesting to watch, and how that has an impact on the UK, because of course it'll impact on these like trade agreements and arrangements as well in terms of protections across different jurisdictions. And next, sorry, I'm rabbiting, so just moving on to the next slide. Just a bit of impact on workers, and a lot of the AI information and reporting is very, very negative, and I think there are some good things coming out of it too. But and I'm conscious that whenever, certainly the last however many years, when we talk about employment law, it's often a bit negative because we're often saying there needs to be more, or the protection is not good enough. So, but there are some good things. It does have an impact, of course, and I think we're all aware of cases where the algorithms and the way AI can sift and go through recruitment processes has already caused problems. And the stereotype of that is US predominantly males in their 20s designing the kind of the processes that are then played out in the workplace. And I think Amazon abandoned their own automated job applicant screening because it was found to bring in sort of elements of discrimination and prejudice that are built into it in terms of the way it deals with things based on previous data. And of course, another factor is sometimes unintentional, to be fair to them, because of course, if in the past the data shows that males have been more successful, I'm not suggesting that's right, because it certainly shouldn't have been, but if that's how it has been in the past, then if AI is picking up previous data, they're going to adopt that. The risk is they adopt that data when assessing future applicants. So actually, rather than it becoming a diverse and an equal workforce, it's continuing the existing prejudices that may have been adopted in previous years. So that would be, you know, an awful way of it filtering out more diverse and more gender-wide applicants. But also operational management. I think this is a big thing now. For example, I understand that Thorpe Park, the amusement park, now uses AI to allocate its shift patterns in terms of customer demand, and it calculates staffing, and that's purely AI driven with some human oversight, but in terms of staffing. But also it has been operating in terms of assigning work. So Uber have had a scandal where their own AI application for assigning work apparently favours those with lighter skin complexion, believe it or not, in terms of allocating work, which is obviously disgusting. But those prejudices can be inbuilt. but it can help cope better with customer demand as well. So it can have a favourable aspect there. And also, when we get into the worker monitoring, but not just monitoring, but also performance reviews, and the data can be gathered through the use of AI in terms of an individual's annual appraisal, quarterly appraisals, performance reviews, which of course can bring in skewed data. On a slightly more positive note, recently M&S have identified that when they tied in their CCTV and AI analysis of performance and movements in their 19 distribution centres, they cut accidents and incidents by 80% within 10 weeks of adoption. Now, if that's correct, then that's an astonishing drop in the number of injuries caused in the workplace through that sort of monitoring process. So I guess it's a mixed bag, really, of good things and bad things. But the key thing is, from an employment law perspective, the existing employment law protections are there. And Nick and I had an interesting conversation when we were looking at sort of decisions made by AI, and we were talking earlier before we started, decisions made by AI in the recruiting process, and whether an employer can say, well, it's nothing to do with us. It's our AI that does it. But I think ultimately that's not going to be the case, that there will be responsibility. There has to be for the company or the employer that adopts the AI in terms of the consequences of the AI's actions, which increases the importance of having a human element of monitoring it and having human control. The fear is if a company or an employer cuts costs and they remove staffing, then that could remove the human oversight of the AI, and that's where I think it could cause real problems. So like any newish technology, it has to be carefully assessed and monitored. So it's certainly another thing for us to think about and worry about in the future. And I don't think it's going to be going anywhere anytime soon. So we're going to have to get used to it, but hopefully modifying it, getting it regulated and getting it controlled so it behaves appropriately and doesn't bring in prejudice in terms of assigning work or even creating jobs, or signing contracts and so on as well. So a bit of a ramble. I think I've just sort of covered a bit of that as well. In terms of the upsides. Sorry, Nick, would you mind just going back one? Yeah, just I suppose just to look at the overall picture. Improve safety, removes repetitive menial tasks, possibly faster responsiveness to customer demand. But on the downside, of course, the loss of human control, which can impact on morale, pride. Obviously, the big fear is loss of jobs. Hopefully, there'll be creation of other jobs that form alongside, but there's a worry about jobs. And certainly we've got we take on 2 legal apprentices every year. These are school leavers who it's a fantastic scheme now where they come, they do a 5 or 6 year apprenticeship, they have a day release and they study at university, and we fund that through. But of course, when we had our interviews this time around, each question they asked was, when say, have you got any questions for us? And they're like, yeah, what's the impact of AI on law? Because teacher says there aren't going to be jobs in law in 5 years. And so there's all these questions as well in terms of, and of course that plays out to the music industry, into manufacturing, into finance, all the other sectors as well, as to what's the impact. So that is yet to be seen. There may be less jobs in certain areas, I think, and that's one thing we've got to get used to, of course. Referred to the removal of human supervisory management level. There's also, with my cyber hat on, potential cyber and data risks, because there is talk in terms of cyber criminals getting access to AI and adopting those tools, either subverting them or getting access and using them in terms of cyber crime. So there's those sort of balance risks as well. Right, I think that's it. I'm happy to answer any questions.
Excellent. Thank you very much, David. Just first of all, I think there was something in the chat just to clarify. You mentioned the 3-month non-competition limit on that. Is that just on the non-competition? Is there anything to do with notice, or and to take that one further? I don't know if this is a legal thing or just like a company decision. If someone was on garden leave for the notice period, would that impact on the length of that non-competition clause as well?
Yeah, no, that's a great question, because it's weird that it just applies to non-competition and not to other restrictions. And on the face of it, it's only a consultation at this stage. On the face of it, there can still be lengthy notice periods. So what it's not unusual for 6 months or even 12 months in certain roles, notice periods. And how does that sit? Because of course, if you're on a 6-month garden leave period, say, but you can only prevent someone from competing for 3 months, they're still employed by you. So what are they going to do? They can, in theory, compete with you, but then they'd be in breach of their other possible terms as well. And so, yeah, how that's going to fit together remains to be seen. I really think it's, frankly, from my point of view, an answer to a problem we don't have. And I don't think it's much of an answer either. But it's going to cause some headaches. I wouldn't be surprised if they withdraw it, because I would imagine there'll be certain vested interests that will be seeing the real downside to this from a sort of institutional or company level. So we'll see where it goes. There is some general movement in the EU and amongst other countries to try and bring limits on this as well, but I'm not sure that our approach that's suggested is going to be the best answer.
Yeah, I mean, in my experience, it's always just negotiated down anyway. So, as you say, it's not a problem that really exists. But there we go. I did have one question as well. I mean, just I guess in your opinion, this extra 6-month protection for from redundancy for people on maternity leave, often, you know, in this, what I see is people on maternity leave are made redundant. You know, they are paid up their maternity pay and made redundant. So if that sort of situation happened, I mean, I guess it's restricting that sort of situation, because the employer would then have to pay an extra 6 months full pay on top of that. So is that how you see that restriction kind of having that impact?
Yeah, I mean, I think there's always an area of weakness in our experience in terms of I think, you know, in terms of the levels of discrimination claims we see or questions we get, those who are on kind of family-friendly rights in terms of shared parental leave or maternity leave, those returning from those who are pregnant are often in. There are quite a number of those kind of matters come through to us. So there's definitely an area there where there are dismissals, and it could be, yes, that's right, that it's sort of there are ways and means to get around it. But I do think it's still, I think the protection they're bringing in, subject to the detail, which we've got to see, because this is we're waiting to get more detail. But I think it's definitely going to be positive. So it will help in terms of at least put the word out there that there's extra protection. That in itself can be deterrence as well. On, let's be honest, these kind of employers tend to be the bad ones, those who target individuals who want family, you know, exercise family rights, have kids, adopt kids, etc., have caring responsibilities.
Thank you. Fiona asks, are there any other exemptions from 2P in the pipeline that you know of, or with less than 10 staff, or is it just the consultation aspect?
It's just the consultation aspect at the moment. I mean, I've always worried that the ghost of Margaret Thatcher will rise up and cut 2P, because it does seem to be something close to her loyal followers' hearts, really, because she particularly hated 2P and real problems with it. And the fact that the EEC got pulled one over on her and made her implement it, because we were literally being sued to implement it, has stuck in their throat. So I wouldn't be surprised if there's other things. Now, on the positive side, we've also got to bear in mind the trading relationship with the EU as well, because while it's not often commented on, obviously, if we do start cutting employment law protections like 2P, then that's going to flag up a potential trade war that might develop, which hopefully nobody wants, given the impact we've been experiencing over the last couple. We don't want to make things any worse, I'll put it that way. So hopefully they will back off, particularly as we get closer to the next general election.
Just a request to repeat the stat on employees being monitored. Can you repeat that again?
It was, I read it yesterday. It's something like, and let me fish it out and send it over to you. But it looked quite credible. But it showed, and I think it was referring to software monitoring in terms of computer use, and I think particularly the kind of home working, remote working type monitoring. And I think it was something like 65 to 70% of employees generally in the UK are being monitored in terms of their use. And that can be, as I understand it, I'll just say, as a firm, we don't monitor. So I'm not talking about practical experience. You know, we trust our staff to do a job. We don't need, but I know there are different levels. So I was looking into it in terms of this stat, in terms of keyboard monitoring, in terms of activity, in terms of mouse movements, in terms of all those things as well. So it kind of encourages individuals not to use paper, because of course you write things down on paper or a paper file, you're not using the keyboard, and also encourages greater use of Teams and so on, because of course using the keyboard rather than a face-to-face meeting. So it kind of encourages different behaviour to hit the stats, which can be extremely negative as well. But yeah, the kind of monitoring seems very significant. But I'll tell you what I'll do. It was in my research yesterday, so
Yeah.
I'll find the stat and I'll send it over to you, Nick. If I
No,
may.
yeah, that's great. And is it okay if I put the slides on the website as well as the
Absolutely,
recording, and then I can add that to it as well?
Yeah.
There's a comment here which I'm not sure if you'll know the answer, but it would be interesting to see M&S, their employees' reaction to the health and safety monitoring, and whether or not actually they saw it as a positive thing, or whether it was overbearing investigation into what was happening or whatever. And also, I mean, I thought to myself, 80% sounds great, but if there were 5 accidents and then just one in the next 10 weeks, that's obviously a different stat. So that might be some more information which would be useful to have there.
Yeah, I mean, it's very true. I mean, it's always sort of rolled out, isn't it, by the companies? It's for your safety, do these things, and of course we won't use it in disciplinary proceedings.
Yeah.
And then of course things change, and it does get used, and so on and so on. And mission creep in terms of getting more and more. So I'll see what I can find on there as well, because it's quite interesting. That was sort of one of the few positives I found in the research about AI.
Well, Kevin said that there's an opportunity for people to run training on equality, diversity, and inclusion for AI robots. So maybe there is an opportunity there for us all to put on some more training opportunities for our robot overlords. Mike Calvert says, perhaps should define what we mean by monitor, as I'm sure there's a wide range variety from perfectly reasonable to protect the employer security to the highly intrusive, e.g. mouse movements, keystroke counts, etc. I think that's I'm monitored because my boss sits over there. So what does that does that count?
Yeah, it's getting the balance right, isn't it? And it's like anything, it's having the policies in place so that people know what they're doing, what the monitoring is. So if there is a level of monitoring, having it in place, explaining it, having those. It's like we go back to that social media case. It's having a clear social media policy. So people want to know what they can and can't do, and you're going to get people who go beyond it, but you need to know it. It's where you don't know that the problems lie, and that's where members can get into real difficulties, because they're simply, in a genuine sense, ignorant of the policy because they've not had it provided to them. But that's the important, and trained.
Absolutely, I think that's key, and I've seen it in places where, as you say, we will not use this. This is only if we get complaints from members of the public or whatever. But then it's creeped in. So making sure individuals know that policy and making sure that the policy itself is enforced fairly by the employer. I think that's about the questions that we've all had. There were a couple that are typing, but if any come through, David, do you mind if I do pass them on and we can try and deal with them outside of this? But conscious of time, but just saves me to say thank you so much for that. I think it was really interesting. Just for everyone, I'll put this up on the website again, and if anyone in your organisation you think will be interested in this, then just pop them there, probably tomorrow, along with the slides and any other information we get. So David, thank you very much.
Thank you very much.
See you again. See you all again.
Thank you. Bye-bye.